So this is Brian Steele's additional motion to disqualify lawyers Love and Hylton. Notice that it was filed at 2:57 p.m. That was less than 30 minutes ago. So we know what the beginning always says, but the Honorable Court denied Mr. Williams' original motion to disqualify lawyers Love and Hylton on August 1st, 2024, based upon Mr. Williams' assertion that he intends to call lawyers Love and Hylton as witnesses at trial. Mr. Williams respectfully requests this Honorable Court to consider the ethical violation, so this is the new reason, made by lawyers Love and Hylton in support of this motion to disqualify. And we're getting a reference to Ford Motor v. Young. The enormity of violations of candor with the court, candor with counsel, and the denial of ethical prosecutors on this case are too much to permit lawyers Love and Hylton to continue as, and shout out to Thugger Daily, I'll link to his Twitter as soon as we're done reading this, as lawyers in this litigation. The below is just a touch of the constant misconduct by lawyers Love and Hylton in this case. 1. Recently, lawyer Love filed a motion with this Honorable Court that undersigned counsel had a, quote, duty to provide work product. Lawyer Love knows the same is untrue, and the cases that she cited in the said motion did not support the propositions of law that she asserted in the motion. So she's referring to the motion to compel defendants' compliance with reciprocal discovery obligations. This was the 4th time that lawyer Love raised the same frivolous issue, attempting to hide Georgia law from this court that she was explained at the 3 prior hearings on the same exact issue. So here we have some citations to those hearings. Back April 8th, 2024 is one of them, and then we have July 30th, 2024. 2. In paragraph 11 of the state's ex parte motion for order to compel testimony necessary to the public interest. So this is talking about the immunity, I think. There is zero truth to the assertion. We haven't seen that copy, but they have. They saw it last week. Steele is saying there is zero truth to the assertion that any defense meeting occurred with Mr. Copeland to impact Mr. Copeland's decision to invoke the Fifth Amendment or any other matter. Stard tackled this in what we read on Friday, I think. No defense lawyer on this trial had any connection or involvement with Mr. Copeland on or around June 6, 2024. This is a knowing misstatement by lawyer Love. Prior to opening statements, the former court ordered all parties to share with did it go to the right page? Let me make sure it went to the right page. Prior to opening statements, the former court ordered all parties to share with each other any demonstrative aid that they would seek to display to the jury during opening statements that were to begin on Monday, November 27th, 2023, so that objections could be made prior to presentation of the opening statement. And they cite back, we watched that recently, Nick Starr replayed the opening statements, and we saw him call for a mistrial, right, during opening. On Friday, November 24th, 2023, at 4:58 p.m., lawyer Love shared her supposed demonstrative aid. During opening statements at trial, lawyer Love showed a completely different demonstrative aid in violation of the prior court's order. So they cite to that on November 27th. There have been no consequences for lawyer Love's intentional, unethical, and continued misconduct. 4. During the same opening statement, lawyer Love defied another pretrial former court order without first obtaining permission from the now recused court by introducing to the jury that undersigned counsel had represented another person charged in this case. And this is back to that PowerPoint from opening statements. Specifically in her PowerPoint, lawyer Love showed the jury that undersigned counsel represent co-indictee Blaylock. 5. Lawyer Love accused undersigned counsel of knowingly and intelligently misrepresenting to the jury that Mr. Bean was taken to Grady Hospital by police from the scene of his arrest on September 11th, 2013. At a bench conference, lawyer Love falsely stated that she had evidence on her table to prove. And I see you guys say that the document's there, so I'm going to pull it up. We'll read the rest from... Wait, I don't see the document link, actually. So we'll go on to page 4 with the picture, but as soon as I see a document link, I'll share it, or I can pull the document. That counsel fabricated evidence, as Mr. Bean never went to Grady Hospital on September 11th, 2013. And then he cites the YouTube lawyer. And remember, yesterday in court, Brian Steele mentioned he's provided a thumb drive with YouTube videos that he references. So yes, he's linking to the YouTube videos in these motions, but it seems like he's preserving downloaded files of the recordings. He's not just relying on YouTube to stay up forever. Lawyer Love's allegations against undersigned counsel to the prior court were proven beyond any doubt to be totally, knowingly false. And then 6, over Mr. Williams' objection, when the state was attempting to introduce a January 26, 2015 social media posting from co-indictee Garlington's account during the testimony of Detective Gaither, Lawyer Love told the prior court that only Mr. Williams' voice could be heard on this video and audio, except for one other voice saying, "yeah," in the background. I remember this. Undersigned counsel told the prior court that Lawyer Love was incorrect and that several persons' voices were audible in the social media posting. Lawyer Love falsely accused undersigned counsel of misrepresenting facts to the prior court. Of course, Lawyer Love was proven to be the person who was untruthful and was again falsely accusing undersigned counsel of wrongdoing. This pattern of prosecutorial misconduct illustrates the enormity of unethical conduct of Lawyer Love and the state of Georgia in this case. And then, yeah, we have the footnote here that Lawyer Love never introduced the evidence on her table. So you had it on your table, you say, but like, what's up? And then next page. Reason 7, on Thursday, June 6th, 2024, as well as Friday, June 7th, Lawyer Love falsely accused undersigned counsel of purposefully extracting and tampering with jail recordings of Mr. Copeland. Again, this was another knowing, malicious, false allegation by Lawyer Love as she continues her unethical conduct. And then 8, on Monday, June 10th, Lawyer Hylton, Lawyer Love, and the now recused trial court attempted to hide Brady evidence from Mr. Williams and the other accused that was obtained during the unlawful ex parte meeting with sworn witness Copeland and his counsel. Specifically, Mr. Copeland made statements that everything he says is a lie, that he committed all of the crimes in the indictment and the like. These statements are impeachment of Mr. Copeland and are squarely within the concept of Brady v. Maryland. Moreover, lawyers Hylton and Love, with the assistance of the now recused judge, told Mr. Copeland that he would not get in trouble if he lied under oath unless he told a bold-faced whopper of a lie, that he could not be prosecuted based upon some erroneous theory that the statute of limitations has run, and Mr. Copeland would have to remain in custody until all 28 co-indictees' cases resolve. This is all unethical conduct in order to intimidate and coerce Mr. Copeland to testify at trial. And then we have one short closing here that specifies, and we'll get back over to the hearing, that the above does not truly encapsulate the horror of working with Lawyer Love and Hylton, not to be able to trust the prosecution to provide the simplest and most basic fundamental fairness, such as honesty to the tribunal and honesty to all in the courtroom, must mandate that both Lawyers Love and Hylton be disqualified from the case. So Williams requests a hearing on this motion, and at the conclusion asks for the relief to be granted. There you go. So I'm going to get this link. We're going to get this back on, this hearing. We'll catch up.